Can you get sued for wholesaling real estate, and how can you avoid it? Guys, it's Rick Ginn here with Flip with Rick, and we are going to attack on how to protect yourselves from getting sued as a wholesaler. Now, before I get into it, do me a favor, smash that like button, hit that subscribe button to continue to receive the absolute best information on wholesaling today. So, can you get sued wholesaling? And the definitive answer is you can get sued for anything. So let me start off by saying in 20 years of doing wholesaling, I have been sued. I've been sued multiple times. In the long run, it's not a matter of if you're going to get sued. It's just a question of when. And I'm going to break down the basic 3 areas where you're mostly going to be exposed. And I'm going to give you an insight on stuff I've gone through on personally being sued and how to navigate, and more importantly, how to avoid it. So the first thing you got to understand is when you get sued, there's 2 types of lawsuits. One is criminal. That's the worst one. You really don't want that one. And that one's going to be brought on to you by a state attorney. And it can be state, it can be federal, but most likely it'll be state. And this is the one you really don't want to do it, because that's the one that puts you behind bars, okay? The reality is, unless you do something horrible, meaning it doesn't matter if you're a teacher, doctor, a lawyer, or a wholesaler, if you are up to bad intent, meaning you are just going to break the law, then you're going to get criminal offenses. So we're not going to spend a lot of time on that one today, because either you're good or you're not, in my opinion. So what we're going to primarily focus is on civil lawsuits. So a civil lawsuit's where basically somebody sues you and they're going after financial damages. So they can go after assets, they can go your entire net worth, and that's what most people sue for. So I am going to preface this by telling you I am not an attorney. I am not giving you legal advice. I am not giving you financial advice. I'm just giving you my opinion on how lawsuits work and how to avoid them in wholesaling real estate. So, guys, once again, I'm not an attorney, and you need to seek legal professional advice to protect you in your particular state. So, that's right. I've been involved in lawsuits, and I will tell you, they've all been civilly, never criminally. Like criminals, just you did really bad. And the main thing in a lawsuit you have to understand is when you get sued, you basically get served. And the serve part is probably the most shocking part, because they hit you at your home, they hit you at your business, they'll hit you at the gym, and a representative, usually some sort of carrier, or sometimes even the sheriff's department serves you. The person suing you has that choice, and a lot of them do it to create the most shock and awe. So there's nothing worse than when a police officer pulls up to your house and serves you with a lawsuit. Now, keep in mind, I can sue you and you can sue me. That's how life works. In the United States, there is no penalty for just suing somebody. Now, if you go over in other countries, the person who sues, if they lose, they have to pay all costs involved, and then they're subject to damages. In the United States, it doesn't work that way. So, typical lawsuit, you get 20 days to respond. If you've never dealt with a lawyer, you've never had to deal with it, it is very frantic, and it just sucks. There's no other word for it. Remember, people can sue you for anything. It's just their opinion. So what they typically do is hire a lawyer. They write up a complaint. They file. You got 20 days to respond. And I'm here to tell you that there's 2 strategies when people sue you. I figured this out. 90% of lawsuits never make it to trial. Okay? At least the ones I've dealt with, and all the ones I've ever been associated with or talked to. The reason usually for a lawsuit is to basically put you in a position to say, hey, I give up, I surrender. It's easier to pay this guy or gal as opposed to fighting with an attorney and going to trial. Okay? And so that's usually what's done. So the few times when I got sued over some stupid civil matter, when I first got out in wholesaling, it didn't happen until year 3. And what happens is they just have relentless amount of attorneys going after you. So you have to make a business decision. Is it cheaper to settle with them, or is it cheaper to fight the lawsuit? Most of the time, I'm just going to tell you the truth, it is easier to settle a lawsuit unless your attorney can flat out get it dismissed. Lawyers are very expensive. The average lawyer fee is in excess of $400 an hour. And the average court case, if you take it to court, can run you hundreds and hundreds of hours. Do the math. So sometimes people are just shaking you down for payment. Like, you got to know it going into it. If it's a BS claim, then most likely you can get it dismissed. But if you have some liability, they're looking to get money out of you. This happens all the time in real estate. And I want you to understand, when you get served with a lawsuit, it doesn't mean you particularly did something wrong. You just exposed your business. So the basic element to protect you in any of these lawsuits is to make sure you do not get sued personally. How do you do that? The best way to protect yourself is simply open up an LLC, and you write your contracts, especially your assignment contracts, and you put them in your corporation's name, the LLC. Okay? That's imperative because you do not want to be sued personally, because then they can access your personal funds, everything else you do. So the number one way to prevent people from attacking you is make sure you run your business at least in an LLC or an Inc. Okay? So the second thing you've got to understand is, when a civil lawsuit is filed, if you had to sit in front of a judge and potentially a jury, is they're going to use the common sense test. Okay? So if you were doing something, they're going to try to target in on your intent. Okay? So whenever I do something and I go forward, I always pretend I'm standing in front of a judge or a trial jury, and I go, what would they view this action I'm getting ready to take? So if you're not sure about your action and you think it might be gray, think about yourself standing in front of a judge and a jury, and that will help you write your decisions. The first time I had to stand in front of a judge, I said, I'm never going to be put in this position again. I'm just going to do the right thing. And I want you to look at the best way to prevent a lawsuit is look as if a jury member or a judge is looking at your intent. How do they find your intent? They look at all the clues, the paperwork, the recorded conversations, whatever the seller or the new buyer is going to say, and that's how they're going to do it. So I'm going to walk you through the 3 ways you're most likely to get sued in real estate as a wholesaler. Number one, the biggest one, and I put this one first because it's most common thing, is slander of title. Slander of title is basically when you go on public record and you record something against a property's title, aka a affidavit of memorandum, which basically says you have an equitable interest in the property and somehow the seller backed out of the deal for you or they didn't follow through. That's the most probable area where you're going to get sued, because you got to understand, when you slander title, you attack someone. And when you do that, they have the ability to countersue you or actually sue you direct. So if you slander that title and they hire an attorney and the attorney goes through all the details of your contract, did you put down the earnest money deposit? Did you execute your contract? Did you show up to the closing? Did you actually have funds ready to be able to close to it? Did you meet with the title company? Did you call the seller multiple times before you closed? And they're going to look at everything under a microscope. And if you pass all that stuff, then you might have a shot. But if you missed the earnest money deposit, you never showed up to the title company, you never had proof of funds, you never made any phone calls, and you recorded this memorandum, then now you were open to slander of title, and now it's open to a judge, possibly a jury, depending on what your contract says, to what the damages are. Did the seller suffer damages? If they couldn't sell their home in a timely manner or had to make more mortgage payments, you are typically going to be punished. It could be anywhere from $5,000 to $10,000. Plus, you have to pay their attorney's fees. So it can add up quickly. I find slander of title, a lot of wholesalers are getting reckless. Keep in mind, if you're going to prepare something and record it on public record, make sure you consult an attorney, because you could be wrong and you could be liable for a counter lawsuit. The second one, which we all want to avoid, is fraud. And this is of the criminal nature. A fraud is when you deceive somebody on the material facts. You flat out lie to them. You misrepresent it. Guys, you can't do this in wholesaling. Even if you do it once, it's going to catch up to you. For this reason alone, do not do fraud. It's not worth it. It's not going to work. And if it ever gets in the eyes of the court, your intent will be busted wide open. Do the right thing. If somebody's not going to agree to a price, trying to trick somebody into signatures or trying to manipulate a document to make a deal work is the worst thing you can do, because I promise you, the penalty of fraud on a felony conviction is going to be so much worse than whatever gain you're going to deal. If you ever get tempted by it, run. Keep in mind, I'm going to stand in front of a judge. I'm going to stand in front of a jury. I don't want to do this type of stuff. The second one is transacting in the so-called illegal states. So you guys all know how Oklahoma and Nebraska work. Basically, there's laws on the book by the states saying you can't publicly market your real estate. And if you do that without a license, you are breaking that statute. Now, I'm not here to break down the statute and get the details of it, but what happens is a state attorney can now impose civil punishment on you. And basically, you have to defend yourself. But honestly, it's going to be black and wild. You're going to get nailed on it. Make sure if you're in one of those states, you are following their marketing laws, and make sure you cover yourself. Now, if you're in one of the separate states, Illinois, where you can't do multiple properties, understanding if you do it and the state decides to enforce it. Remember, a big part of these civil lawsuits is the enforcement. There's a lot of laws on the books the states don't even enforce right now. And when you get new laws like this, they usually give a grace period. But sooner or later, they might come after you. So if you're in the state of Illinois, consider getting a real estate license, as much as I hate doing it, if you want to survive in those states without risk of getting a civil lawsuit penalty. And guys, when the state sues you, it's bad because their attorneys are on the payroll. It's like they have unlimited funds to sink you, and they're going to take that action when they do it. The third way you're going to get in trouble, which is very, very common, is basically the TCPA compliance laws. And honestly, I'm not the expert on this, but if you use a lot of common sense when it comes to cold calling, like don't call before 8 a.m., don't call after 9 p.m. I wouldn't call on Sundays. I try not to call on high holy days, stuff like that. But honestly, the best way to protect yourself is just use the ZachDialer.com so you can get your list scrubbed to make sure you are compliant. That is the biggest thing. Guys, when it comes down to it, lawsuits, anybody can sue you. And what I find is when somebody says they're going to sue you, 9 times out of 10, they never do. It's a threat. Most lawsuits are threats to get you to do something, either to compensate them or back down on a contract. I can't tell you how many agreements I got in where I got sued and they go, listen, if you sign this release, we'll go ahead and drop the lawsuit. So understanding most lawsuits civilly are a form of leverage, and you've got to protect yourself. Make sure you guys, if you're operating a business and you're doing it on a regular basis, my recommendation is set up an LLC. But guys, at the end of the day, you will always be judged on your intent, okay? And remember, even when someone's not looking, you need to self-police yourself and go, okay, here's my actions, here's my intent. If I do this, I know what the risk is. Guys, honestly, it's just better off doing the right thing. Just follow the law, and it's much, much easier, and you will last a long time. Anybody who cheats and decides to manipulate wholesaling real estate, they always, always get caught, and it sinks them financially. Their credit's destroyed, and some of them actually go in and commit fraud, and it's 10 times worse. But guys, really, the best way to prevent any of this stuff is just do the right thing, even when people aren't looking, and this is the best way to avoid these lawsuits. So let me know in the comments below if you think these things will prevent lawsuits, and what are you at most risk for in a lawsuit in wholesaling real estate, in your opinion. I would love to hear the information, guys. Do me a favor, smash that like button, hit that subscribe button to continue to receive the absolute best information on wholesaling available today. Guys, this is Rick Ginn, and I'll see you in the next video.